ethnic Armenians. The children of Azerbaijan are taught to hate and kill Armenians in their school textbooks. The state media spews vile hate speech. Public officials dehumanize ethnic Armenians and call for their complete elimination. This is the pervasive state-sanctioned racism that Azerbaijan's council dismissed yesterday as so-called Armenophobia. A climate in which literal axe murderers are awarded, promoted, and glorified as national heroes for killing Armenians in peacetime. This long-standing state policy of racial hatred came to a violent head in September 2020, when Azerbaijan launched a war of aggression against the ethnic Armenians of Nagorno-Karabakh. The stated goal was to eliminate and expel ethnic Armenians from their homeland. As President Aliyev later revealed, quote, "Hatred for the enemy was driving us forward," end of quote. For 44 days, Azerbaijani soldiers systematically murdered, tortured, and abused ethnic Armenians. They gleefully filmed themselves carrying out unspeakable acts of violence against ethnic Armenian civilians and prisoners of war, all while shouting racial slurs and insults. Through this violence and intimidation, Azerbaijan ethnically cleansed large swaths of Nagorno-Karabakh in 2020, expelling at least 30,000 people from their homeland. President Aliyev declared victory, proclaiming that no songs will be sung in Armenian in those lands ever again. In the aftermath of these shocking atrocities, which were the culmination of decades of racial discrimination against ethnic Armenians, Armenia sought accountability under the CERD. Importantly, Armenia also sought the court's urgent protection for those vulnerable ethnic Armenians who, at the time, had not yet been killed or expelled from their homeland. Mr. President, members of the court, we all know what has happened since then. To the deep regret of Armenia and the international community, not even the court was able to stop the tide of Azerbaijan's racist campaign of ethnic cleansing. In September 2023, after starving the ethnic Armenians of Nagorno-Karabakh for 9 months by blocking the Lachin corridor, in flagrant violation of the court's first 2 orders on provisional measures, Azerbaijan launched an unprovoked attack, killing hundreds and forcing over 100,000 ethnic Armenians to flee their ancestral homes. To this day, almost 200 remain missing, and their families suffer without knowing the fate of their loved ones. Just as with the court's previous orders, Azerbaijan remained in defiance of the court's 3rd order of 17 November 2023. It has done nothing to, and I quote, "ensure that persons who have left Nagorno-Karabakh after 19 September 2023 and who wish to return to Nagorno-Karabakh are able to do so in safe, unimpeded, and expeditious manner," end of quote. After threatening to do so for years, Azerbaijan has completed the ethnic cleansing of the region and is now consolidating it by systematically erasing all traces of ethnic Armenians' presence, including Armenian cultural and religious heritage. All this is happening while this case is pending before you. Just last month, President Aliyev lit a bonfire in Stepanakert, Nagorno-Karabakh, and tweeted that the bonfire was, quote, "doing the final cleaning," end of quote. Mr. President, members of the court, this is the context in which Armenia is pursuing claims against Azerbaijan under the CERD. faced with Armenia's claims and overwhelming evidence against it, Azerbaijan has desperately sought to introduce a false sense of parity between the parties by instituting its own case against Armenia. But the challenge for Azerbaijan is that it has no videos of racist atrocities to show or no pervasive hate speech by public officials to quote. So what Azerbaijan has done? It has resurrected 3 decades-old historical grievances that clearly fall outside the temporal scope of the court's jurisdiction. Just yesterday, we heard Azerbaijan misrepresenting an early 20th century national ideology as racist, which has nothing to do with the mainstream political realities in Armenia today. Azerbaijan has also introduced outlandish claims about alleged environmental damage that have nothing to do with racial discrimination. And it is even attempting for a 3rd time to convince the court that its allegations about landmines fall within the scope of the CERD. As Armenia will explain during the hearings that begin next week, the vast majority of Azerbaijan's claims fall squarely outside the court's jurisdiction. Yet again, however, Azerbaijan is pursuing its same tired strategy of mirroring and whataboutism. It is undoubtedly aware of the jurisdictional challenges faced by the case it has brought against Armenia. It is now desperately attempting to convince the court that Armenia's case also faces jurisdictional hurdles. But nothing could be further from the truth. In light of the manifest weakness of its objections, Azerbaijan is simply hoping that the 2 sets of objections will cancel each other out. Mr. President, members of the court, this is a cynical strategy of last resort. As Armenia will explain today, neither of Azerbaijan's objections stands up to even cursory scrutiny, and its tactic must fail. Azerbaijan's first objection is simply not serious. Not only does Azerbaijan's understanding of the negotiation requirement of Article 22 turn the court's jurisprudence on its head, Azerbaijan's presentation of the facts also distorts reality. What Azerbaijan refers to as negotiations about negotiations was in fact an agenda imposed by Azerbaijan with the sole purpose of prolonging negotiations for as long as possible. What Azerbaijan refers to as confidence building exercise was happening at a time when the Azerbaijani army was still expelling ethnic Armenians from their homes. When Azerbaijan was making so-called proposal for joint action, it was also torturing ethnic Armenian detainees and destroying Armenian cultural heritage. While Azerbaijan, as it claims, was making progress in negotiations, it was opening its military trophies park and ridiculing ethnic Armenians with racist mannequins. Mr. President, members of the court, in such a context, 1 year of negotiations was 1 year too many. Armenia nevertheless negotiated with Azerbaijan in good faith and pursued discussions far beyond the point of futility. Armenia has fulfilled the requirements of Article 22 in letter and spirit, and Azerbaijan's first objection fails. Azerbaijan's second objection is also without merit. Unable to even argue that the vast majority of Armenia's claims fall outside the court jurisdiction, Azerbaijan attempts to convince the court that a subset of Armenia's claims concerning violence, detention, and enforced disappearances have nothing to do with the CERD. To do so, Azerbaijan relies on at least 2 fictions. First, it tells the court that Armenia simply does not have enough particularized evidence of racial animus. Apparently, according to Azerbaijan, for the court to enjoy jurisdiction, Armenia should prove that each and every instance of violence, detention, or disappearance was sufficiently racist. And to do so, it is not enough that Armenia point to a general climate of hate speech, or to the most hateful atrocities, or even to the racist words of the perpetrators themselves. For Azerbaijan, Armenia must prove an elusive something else. Azerbaijan's other fiction is that Armenia's grievances fall outside the scope of the CERT because they implicate international humanitarian law. For Azerbaijan, Armenia is unduly attempting to litigate an ordinary armed conflict between two warring states. As I explained, Armenia's claims concern far more than the 44-day war of 2020. To borrow Azerbaijan's metaphor, the war itself was only the tip of the iceberg of decades of racist policies and practices. That said, the CERT is not displaced by the existence of armed conflict. How could it be? History has shown us that the most extreme forms of racial discrimination, including persecution, ethnic cleansing, genocide, most often occur in the context of armed conflict. Indeed, as set out in the Convention's preamble, and I quote, "Discrimination between human beings on the grounds of race, color, or ethnic origin is an obstacle to friendly and peaceful relations among nations and is capable of disturbing peace and security among peoples and the harmony of persons living side by side, even within one and the same state." End of quote. Unfortunately, there is no better example of racial discrimination upsetting peace and security than Azerbaijan's recent armed aggressions, which resulted in ethnic cleansing of all of Nagorno-Karabakh. In this context, as Armenia will demonstrate today, Azerbaijan's arguments come nowhere near establishing that Armenia's claims are not capable of falling within the scope of the CERT. Mr. President, members of the Court, Armenia will organize its presentation today as follows. First, Mr. Konstantinos Salonidis will explain why Azerbaijan's first objection that Armenia failed to comply with the negotiation precondition of Article 22 of the CERT is plainly without merit. Second, Professor Pierre Darjan will begin Armenia's submissions on Azerbaijan's objection ratione materia by setting forth the well-established legal standard applied by the Court. Third, Professor Sean Murphy will provide an overview of the pervasive Armenophobia espoused by Azerbaijan, which provides critical context for assessing the application of international humanitarian law does not preclude the jurisdiction of the Court. Human rights and the dignity and equality of all peoples, regardless of their race and ethnicity. They are about justice for victims, accountability for perpetrators, and truth-telling for posterity. Yet Azerbaijan has been increasingly characterizing Armenia's human rights claims, whether before the court or in Strasbourg, as some sort of challenge to Azerbaijan's sovereignty or territorial integrity. It further claims that these proceedings are an obstacle to peace between two states. Azerbaijan is profoundly mistaken. Armenia has no claims to Azerbaijan's territory and is also committed to establishing conditions for genuine and enduring peace. But it cannot be the case that, to quote President Aliyev, might is right and international law does not work. A state that has carried out gross breaches of human rights cannot simply declare that it has completed its atrocities and that it is ready to move on. History tells us that lasting peace is built upon justice, accountability, truth, and yes, reconciliation. Thank you for your attention, Mr. President. May I ask that you please call Mr. Salonidis to the podium.
I thank the agent of Armenia for his statement. I now invite Mr. Konstantinos Salonidis to take the floor. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the Court, good morning. It is an honor to appear before you on behalf of the Republic of Armenia. As our Honourable Agent just said, my task today is to explain why Azerbaijan's first preliminary objection must be rejected. Azerbaijan puts forth three arguments in support of its objection. It claims first that the parties never engaged in negotiations. It claims second that Armenia never made a genuine attempt at negotiations. And it claims last, and in the alternative, that Armenia did not pursue these negotiations as far as possible. I will address each of these arguments in turn. I start with the first, the argument that the parties never engaged in negotiations. It is undisputed that before Armenia filed its application, the parties exchanged more than 40 pieces of correspondence and participated in 7 rounds of bilateral meetings over a period of 10 months, from November 2020 to September 2021. Azerbaijan argues that during 7 of those months, the parties engaged in so-called pre-negotiations, and such pre-negotiations are excluded from the concept of negotiations under Article 22 of the CERD. This is because they are, according to Azerbaijan, not about the substance of the dispute. But this slicing and dicing of the overall engagement of the parties has no grounding in the jurisprudence of the court. Azerbaijan says that procedural and technical exchanges, according to the court's own definition, do not qualify as negotiations. But Azerbaijan cites nothing for this proposition. In fact, the court has never excluded from its assessment of negotiations procedural and technical exchanges as long as they are made with a view to resolving the dispute. Indeed, in the Court's first provisional measures order of 7 December 2021, the Court assessed the evolution of the parties' positions from the very first exchange between the Ministers for Foreign Affairs of Armenia and Azerbaijan until the last bilateral meeting. The Court has, of course, done the same in other cases as well. And, of course, the Court's approach makes very good sense. If the Court were to accept Azerbaijan's premise here, then that would mean that any respondent state could indefinitely lock the applicant state into interminable discussions of procedural and technical matters, and thus evade the submission of the dispute to the Court's jurisdiction. It is thus Azerbaijan's position, not Armenia's, that would deprive Article 22 of its significance and meaning. Council for Azerbaijan stated yesterday that 7 months of discussion on procedural and technical matters may seem a long time. This is because it is a long time. And it would have been a much, much longer time had it not been for Armenia accommodating Azerbaijan's requests.
That 7 months of discussion.
From Azerbaijan's very first letter, it became evident to Armenia that it would have to accept negotiating Azerbaijan's mirroring claims alongside its own. It also became evident that if Armenia wanted the negotiations to advance, it would have to accept Azerbaijan's diktats as to when, where, and how the negotiations would proceed. Already 3 months in, Azerbaijan insisted that before proceeding to further discussions, it was first necessary to reach agreement on modalities. Then it was necessary to agree on the scope of the negotiations. And then began a 3.5 months long discussion of procedural modalities and scope of negotiations, to which I will return. But before proceeding to further discussions, I should also point out that Azerbaijan's objection is inconsistent with its position in the case to agree on the scope brought to the court.
To do so for years.
There, Azerbaijan has expressly referred to the very same exchanges and meetings between the parties concerning procedural matters
and the dignity
as a
and
part
equality
of the negotiations,
of all peoples, regardless of their race and ethnicity.
They are about no basis for Azerbaijan to qualify them as negotiations
for perpetrators,
in the Azerbaijan versus Armenia case,
and truth-telling for posterity.
Pre-negotiations.
Yet Azerbaijan has been increasingly characterizing Armenia's human rights claims, whether before the court
Azerbaijan, Armenia
or
does
its
not dispute
as some sort of
the negotiation
an
precondition
overview of the pervasive Armenophobia espoused by Azerbaijan, which provides critical
there is no
context for
principled reason to exclude from negotiations exchanges between the parties relating to procedural and technical matters, as long